Our next speaker is Riyaz Dattu. Riaz is going to address customs considerations, commodity tax issues, and in international transactions. Riyaz Dattu is a partner in the trade law group of McCarthy Tetro, specializing in matters of anti-dumping, countervail duties, customs duties, and other aspects of international trade, and in particular the Canada-U.S. Free Trade Agreement and the North American Free Trade Agreement. Mr. Dattu also belongs to the taxation group of McCarthy Tetro and has considerable expertise in commodity taxation, that's goods and services tax, federal sales tax, provincial sales tax, etc. Mr. Dattu is an editor of a case law reporter service known as the GST and Commodity Tax Cases, published by CCH. And he is also on the editorial advisory board of Canada GST Service, which is published by Debu. Riyaz Dattu has authored various papers on trade law and commodity taxation and has lectured frequently at the Canadian Institute of Chartered Accountants, Canadian Bar Association, Canadian Importers Association, and Canadian Tax Foundation conferences and courses. He is legal counsel to and director of the Canadian Importers Association and also a member of the association's Customs and Legislation Committee. Mr. Dattu received his LLB in 1982 from the University of Toronto and was called to the Ontario Bar in 1984. He received his Master's of Law in 1986 from Osgoode Hall Law School. Would you join me, please, in welcoming Riyaz Dattu?
Thank you, Stephen. I'm going to ask Stephen to help me with the overheads.
I have a job
you've got hard copies of the overheads in your materials. So if you have trouble reading what's behind me, then certainly follow along with the hard copies. What I want to do is essentially provide you with a legislative and administrative framework for importing goods into Canada. And I'll concentrate on importing goods into Canada, but many of the things that we talk about in terms of importing would also apply when you're exporting goods into another country. The reason for that is we're moving more so towards uniformity of laws so that the very same types of requirements that apply in Canada and the same types of regulations that will apply in Canada would possibly also apply in other countries. And as I've said, we're moving towards uniformity. It's something that will happen as time goes on, and in the course of the few years of my practice, I've certainly seen that, and I'll talk about where there is now uniformity in the application of laws. What I also want to do, obviously, is give you some practical advice with respect to importing goods into Canada. In a half-hour session, one cannot cover all the details, so what I hope to be able to do is at least give you an indication of where you can find answers, how to spot the issues, and where you might be able to get the answers to those issues. The first slide shows the order of my presentation. The first 3 points are really the statutory and the regulatory background. Items number 4 and 5 are the questions most often asked. The determination of tariff rate, beyond the tariff rate issues, non-tariff considerations. Documentation requirements is the next item. This is where I think we as lawyers tend to be the weakest. This tends to be the area that is predominantly customs brokers deal with documentation requirements, but you cannot get away without knowing something about the documentation requirement because at the end of the day, it's still the pieces of paper that allow goods to come into Canada. And then lastly, the practical advice as to how to get to some of the answers. Next. I don't intend to summarize all the pieces of legislation that affect importing goods into Canada. There are over 60 by one source, and I've set out for you the principal statutes, and further on we'll look at each one of these principal statutes going down to the Export and Import Permits Act. The Customs Act, very briefly, and I'll come back to this again, regulates the importation of goods, but it is the customs tariff that imposes tariffs on goods. Also, relief from duties is provided by way of customs tariff. The Excise Tax Act imposes other types of levies, such as the GST or excise taxes on goods being imported into Canada. One other statute that seems to be applicable more so these days than in the past is the Special Import Measures Act. You've seen all the dumping cases that have been going around, and I've been spending a great deal of my time doing just that these days. So dumping duties are imposed under the Special Import Measures Act. And lastly, we'll speak briefly about the Export and Import Permits Act, which allows certain goods to come in only subject to the availability of import permits. And the same thing applies in the case of goods being exported in certain instances. It's the next one here. Now, just mentioned that there are 60-odd statutes. In terms of regulations, I didn't try to guess as to how many regulations there are that govern importation of goods into Canada, but to say that they're countless. And like anything else, you don't have to know where all of these regulations are. To the extent that issues come up, I think practitioners rely very much on what are referred to as D memoranda. The D memoranda are issued by customs. There are essentially 21 sections into these D memos, and depending on how you file them, they can be about 3 feet in length in terms of volume 1 going on to the last volume that one needs to refer to. But the D memos provide a great deal of guidance where to look for answers. The D memos are published by customs, and to that extent you have to keep in mind that this is customs' opinion on something, but not necessarily the law, because customs' opinion may differ from what the law is, and obviously that's where lawyers come in terms of interpretation or taking up an issue with customs as to the propriety of their position. Just to give you a sense of what these D memos cover, memorandum, when I'm going to speak of, for example, D6, D6 will have many memoranda under the title of D6. So the D6 series covers refund rules, D7 covers drawbacks, D8 covers remissions and temporary importations, D9 deals with prohibited goods, D10 deals with tariff classifications, and D13 are the memos dealing with valuations or valuation of goods. Those are the principal series that one would look at on a day-to-day basis as a lawyer. There are other D memoranda dealing with accounting and releasing of goods, and as I said, we don't get involved in those issues as much as the customs brokers do. Now, all of these statutes and regulations have an international backdrop, and slide 4 outlines some of these international agreements that cover import requirements. All of these agreements are in some way or other made into Canadian law by the passage of Canadian legislation or regulations. GATT is something that you all know about. There's a current round of negotiation going on called the Uruguay Round, and once that is passed, there'll be a whole bunch of more tariff reductions by virtue of GATT. There are, of course, many other issues being considered under the Uruguay Round. In the previous negotiations of GATT, there were agreements negotiated. A couple of them are the Valuation Code. The formal title for this code is the Agreement on the Implementation of Article 7 of GATT. The Valuation Code essentially sets out the basis upon which goods are to be valued when they come into Canada. The Valuation Code has been implemented in Canadian legislation by way of the Customs Act, in particular sections 48 to 53. Canada adopted the Valuation Code in 1985. Many other countries adopted it much earlier. For example, the US adopted the Valuation Code in 1980. So as Canadian practitioners, we do look to the US quite often for guidance on valuation issues. A couple of reasons: they implemented it earlier, but secondly, just the volume of importation into the US would allow for some of these issues to be considered. More than that, the US system allows for publication of rulings, which does not exist at the present time in the Canadian system. So guidance again is had not only by looking at US jurisprudence, but also looking at opinions issued by the US Customs Service, to the extent that the legislation is quite similar, in fact, in many respects identical to the Canadian Canadian statutory provisions. A great deal of guidance can be obtained. The anti-dumping code is another agreement that emanated from GATT. It's been encoded into Canadian law by way of the Special Import Measures Act, as I mentioned. One thing to note here is that the Special Import Measures Act is undergoing some review, and it may be that when the Uruguay round is decided, our legislation will change, but there's still there's some pressure to have a change in the Canadian dumping legislation even before the Uruguay round concludes. The harmonized system is not an agreement under a GATT article, but rather is I suppose, a system developed by a body that is constituted under GATT called the Customs Cooperation Council. And this council developed a system of classification of goods, and the harmonized system has now become indispensable in developing other agreements. For example, the Canada-US Free Trade Agreement very much relies on the harmonized system of classification. The rules of origin under the current free trade agreement are based very much on the classification rules under the harmonized system. And I'll speak a bit about that. Beyond that, we have bilateral agreements such as the Canada-US Auto Pact. The Canada-US Auto Pact has been translated into Canadian law, and you'll find them in the remission orders and other regulations passed under the customs tariff. There's the multi-fiber arrangement, which is an arrangement that Canada has negotiated with many countries that export textile into Canada. And these are bilateral negotiations whereby there are export restraints as to the amounts that can come into Canada. And the implementation of that occurs by way of the Export and Import Permits Act. NAFTA, put a question mark beside it because we don't quite know whether it'll be here or not next year. Best prediction is it will be here, but who knows. It will, in some cases, replace the free trade agreement. I'm saying in some cases because it modifies certain provisions of the free trade agreement, and obviously will be extended to cover Mexico, whereas the current free trade agreement only covers Canada and the US. The FTA, when it was implemented, was passed by way of statute, and the statute amended many of the other principal statutes that I spoke about earlier. NAFTA has also been passed by the Canadian Parliament. Now it's a matter of the U.S. Side passing, U.S. and Mexican side passing NAFTA through their legislative bodies. I said I would come back to some of the principal statutes. The Customs Act, this is another statute that's undergoing review. One of the things that, and I suppose it's true for many areas of law, but certainly the trade and customs area has been going tremendous change in the last 10 years. Since 1984, we've had a new Special Import Measures Act, which replaced the Anti-Dumping Act. Within 10 years, it's already been felt that the Special Import Measures Act doesn't quite do all the things that importers, exporters, and manufacturers would like it to do, so it's being reviewed at the present time. The Customs Act is also under review. The Customs Act, in fact, was passed in 1986, and within a matter of 7-8 years, it's become outmoded. It took 100 or so years to replace the previous Customs Act, so we got a new Customs Act in 1986, and there's a strong sentiment, and in fact driven by Revenue Canada itself, that the current Customs Act needs to be revamped in many respects. One of the constraints under the current Customs Act is that it works on a transaction-by-transaction basis. So when you have an entry coming into Canada, all of the rules and regulation apply to that one particular entry, as compared to, for example, under the income tax system where you look at a period. The GST system also works on a basis of what's happened during a particular period. So there's some feeling that by moving away from a transaction-by-transaction approach rather to a more period-oriented approach, one can minimize the documentation requirement that goes along with these various transactions. I guess the fundamental way to describe the Customs Act is that it governs, it provides the framework for importing goods. It is the basis upon which other statutes then come in and apply the tariff rate, for example, or provide the relief that is otherwise available, sometimes available for imported goods. But it's the Customs Act that provides the framework for many of these things to happen. It also imposes obligations on importers to report goods and to account for and pay duties on goods being imported. And I've given you the division of the statute. The area that certainly needs a great deal of attention by lawyers in particular is the enforcement provisions. If any of you have been involved in a customs seizure, you'll know that it's not the type of case that you would sometimes expect to be the subject of a customs seizure. It need not be intentional misrepresentation that can lead to a seizure of goods. Innocent misrepresentation, or for that matter, clerical errors of any type have resulted in seizures and massive amounts of penalties being payable. And certainly the Canadian Bar Association, which will be making representations in respect of this review of the Customs Act, is focusing very much on the enforcement provisions. The customs tariff, as I said, imposes duties on goods, but it also provides the framework for many remission orders to be passed. So if you're looking for a special concession, it's the customs tariff that you would try to amend. But also beyond imposing duties, it also provides the basis upon which goods are classified when they come into Canada. And it's a classification of the goods that in many respects, and I'll cover this in more detail later, but it's one of the bases upon which the tariff rate is determined. If you look at slide 6, you'll find the schedules that are part of the customs tariff. Schedule 1 is the most voluminous of the schedules. It contains the harmonized system, and don't know what the last count was, but I think there's something along the line of 10,000 tariff items in Schedule 1 of the customs tariff. And one of the things that lawyers are asked to do is help importers classify their goods in one of those 10,000 tariff items, and depending on which tariff item applies, the rate of duty may differ. In many, to a certain extent, I don't want to get on a box and start preaching, but it seems to me that the area of customs has been ignored in many respects by lawyers. 99% of, and I'm just pulling a figure out of the air, but I don't think it may not be very much off the mark. 99% of the classification issues are dealt with by customs brokers in Canada. It's only in the rare instances that in fact lawyers get involved. And just an anecdote, I mean, I was asked by a customs broker why it is that lawyers should bother themselves with the classification of goods. And I reminded the gentleman that at the end of the day, this Schedule 1 is a provision that is attached to the customs tariff, which is a statute. So essentially what customs brokers are doing is interpreting statutes. And it's an issue that seems to escape many people, and certainly part of the blame for that goes to lawyers, because we haven't really been active in the area of customs very much. I'm told that I've got 5 minutes to finish my presentation, so I'll go a bit quickly. The Schedules 2 to 7 have been summarized in slide 6. Schedule 7 is one that one looks to for some of the non-tariff considerations. It lists out the prohibited goods, and I've later on provided a listing of what the prohibited goods are. For example, used mattresses cannot be brought into Canada. Used cars cannot be brought into Canada other than now from the US because of the FTA. The FTA essentially removed the embargo that existed in respect of used vehicles coming into Canada. The other principal statutes are the Excise Tax Act. It's the principal tax that is imposed under the Excise Tax Act these days is the GST, whereas it used to be the federal sales tax. Special Import Measures Act I've spoken about very briefly. The Export and Import Permits Act sets out a list of goods that are subject to import permits. In some instances, the Import Permits Act merely as a means to monitor the level of imports coming into Canada. In other instances, they act as clear prohibition for goods coming into Canada. In other instances, there could be quotas that are administered through the import control list, so that so many thousand units can come into Canada, but thereafter import permits will not be issued to allow any more products from coming into Canada. I spoke about Schedule 7. I'm skipping ahead now. And the type of goods that are covered by the import control list are listed in item C at the bottom of slide 7. Now, under the heading of determining tariff rate, I think you have to look at 3 subheadings. One is the origin of the goods. The origin determines the rate of tariff that is payable sometimes. The classification of the goods, I spoke about that briefly, which tariff item applies. And then lastly, and this is not really a rate issue, but more an amount issue, the value, because you apply the tariff rate to an amount, which is the value for duty, to get the amount of customs duty that is payable. And I've listed out for you the various types of tariffs that apply depending on the origin of the goods. The ones that apply most often are the most favored nation rate, which applies to countries that are signatory to GATT. The GPT applies to less developed countries, but there are instances where one would be surprised to look at the list. It includes, for example, Korea, and there's some discussion about removing Korea off the GPT list. Certainly because Korea has developed much more significantly than when this system was put into place. The United States tariff, which is on slide 9, is the other tariff rate that applies to a great deal of importation, a great volume of imports that come into Canada. The U.S. tariff obviously applies to goods that are of U.S. origin or North American origin. I shouldn't say North American, Canadian or U.S. origin, because that's under the FDA, it's goods that are of Canadian or U.S. origin that qualify. Once NAFTA comes in, we'll have obviously tariff rates applying to goods of North American origin. So the origin of the goods are very much crucial, but beyond just the where the goods are made, there's also the issue of direct shipment. There are some shipment requirements for goods to qualify, so you have to keep those in mind. Classification of goods, as I mentioned, is based on the Harmonized System of classification. There are 21 sections within the system and 98 chapters. Just next overhead. And there is a great deal of assistance provided in classifying these goods. There are legal notes to the sections. There are also in some cases, legal notes to the chapters. Beyond that, there are some explanatory notes that one has to look at. These are explanatory notes issued by the Customs Cooperation Council. There are Customs Cooperation Council opinions. So there is a great wealth of information that one can look at to assist in classifying goods. Given the time, let me move on a bit more quickly to the valuation side. The valuation system, as I said, was implemented. The customs valuation system that we use in Canada now was implemented into Canadian law in 1985. The principal basis for valuation, one could say that 95% of imports coming into Canada are valued on the basis of the transaction value method. The transaction value method essentially provides for goods to be valued on the basis of the price paid or payable for the goods. And then there are some statutory adjustments. For example, certain types of royalties can be added on to the value or added on to the price to arrive at the value. Royalties that are considered to be in respect of the goods and that are payable as a condition of the sale of the goods to Canada. So you have to not only look at the price, but all the other amounts that may be paid by the importer or purchaser to the vendor or the exporter. Beyond the tariff considerations, and we're on to slide 11 now, are the non-tariff considerations. I've listed out some of these issues for you. We've talked about whether or not the goods can be imported. You have to look at Schedule 7 of the customs tariff or the import control list to determine that. Beyond just the customs requirements, obviously there are other requirements that have to be satisfied once the goods have been imported into Canada, such as whether there's a need to certify the goods under the CSA or UL system. Blake's spoken about the income tax implications. There are obviously GST implications to importing goods. As I said, what I can do for you is just outline the issues that one needs to look at and some areas where you can get some answers. Okay. We're on to the last 3 overheads. I've set out there the documentation requirement. As I said, this is an area that to a certain extent, is best left to the customs brokers because they deal with these issues on a daily basis. But these are the principal documents that one would need to be able to bring goods into Canada. Some of them are prepared by the exporter. For example, the Canada Customs invoice is quite often prepared by the exporter. That does lead to some problems because the exporters, for example, in the People's Republic of China or Taiwan may not quite fill out the documentation the way you want. And there are instances where customs seizures occur because of the exporter having filled out the documentation and nobody on the importer side having checked those documents. The customs coding form is something that is prepared in Canada. It's a coding form that essentially allows for computerized reading of the information that allows the customs officials to decide whether or not the goods are being properly reported. In terms of expertise, what I mentioned in slide 13 is that there's no substitute for developing in-house expertise. I find that I'm most able and most effective in giving advice when there's somebody on the client side who knows about their product or who knows what the importance is of a particular question that is being asked. As lawyers, sometimes being on the outside, we're not able to gauge how important this issue is, and in some instances you may be giving Cadillac service when in fact all that is required is a very basic type of letter rather than a 15-page opinion. So somebody as in-house counsel or customs manager might be able to assist people on the outside as to what level of attention this particular matter requires. But beyond that, just getting information from a corporation is best done through people in-house, and particularly people who have expertise in-house of what it is that the company does. Beyond in-house people, obviously customs brokers are very much involved in the process, but as time goes, the days of customs brokers may be limited as we move into a system of information exchange through computers. Many more companies are not using customs brokers, but rather doing many of these things in-house. So if you're looking at growth industries, don't become a customs broker. Beyond customs brokers, there are in fact many more accountants out there who give advice on customs matters than there are lawyers. So this goes back to my advice about becoming more involved in the customs area. And the last overhead speaks to some of the appeal mechanisms. The port authorities make the initial determinations in most cases of classification or valuation, or for that matter, the origin of goods, for example, whether the goods qualify for free trade treatment. Then there are appeals from the port authority to the deputy minister, and from the deputy minister to the trade tribunal, and from the trade tribunal then to the federal court. In other instances, for example, the customs seizure area, the representations are made directly to the adjudications division that acts in a delegated, by way of a delegated responsibility for the minister. And from the minister, there's an appeal to the federal court. And then there are many situations where there are no statutory appeal provisions. And that's where you would have to use some form of judicial review to get the remedy that you want, either in the form of mandamus or some sort of declaratory action to get the relief that is required. So that, in a way, briefly summarizes some of the issues that one would have to consider in importing goods into Canada.
Are there any questions? Sir?
Okay.
Now, we had occasion to deal with the matter in the United States where there was an error in the harmonized system when they moved from the old classification system to the harmonized system. There was a manifest error. An exemption was not carried forward. And the U.S. Customs Service and U.S. Counsel advised me that there was nothing that could be appealed in the courts because on the face of it, the document said what it said. And ultimately, it was necessary to go through the USTR, United States Trade Representative Office, and get the president to sign a rectification order, which we obtained, and based on that, we were able to get a lot of money back, hundreds of thousands of dollars back from U.S. Treasury. But is there a short way of dealing with that kind of a matter in Canada? In other words, if there's an error in the harmonized system, for the sake of argument, among the 10,000 items, and you look at it and the law is the law, where do you go from there other than bringing an action of some kind?
The same problem existed in Canada when Canada implemented the harmonized system in 1988. To my recollection, one of the few instances where we adopted something sooner than the U.S. was in the case of the harmonized system, which we implemented in 88 and they implemented in 89. For about 2 years or so, there was a fast-track provision to deal with those anomalies or changes in the system not allowing for duty-free treatment of products that were duty-free before. Unfortunately, that fast-track system that existed in Canada has somewhat gone away. What one did in those instances was bring his errors to the attention of the Department of Finance. It's no different than what you did in the U.S. We would do the same thing in Canada, but at least there was a mechanism set up, or there were people set up to look at these issues on a fast-track basis. Now, having said fast-track, it still took at least half a year to a year to get an answer back saying that, yes, things would be improved or the problem would be corrected.
Better than 3 years in the courts.
Absolutely. Even now one can do that, but I think the Department of Finance is going to be less likely to go along with a legislative amendment or an amendment to the regulations simply because the old system allowed for products to come in duty-free. Certainly would be one of the considerations. But as time goes on, I think their view is that we've had the system in place for now about 5 years, and these problems should have been brought out. I think you'd have to bring other factors to play. For example, that this is an input product into a manufacturing industry, and that this will make our manufacturers more competitive worldwide or make us more competitive with respect to finished products made by the manufacturer who's using this input. But the process would essentially be, would require that you make representations to finance. Finance would then check with Revenue Canada and the Ministry of Industry, Trade and Commerce. And based on all the representations that they received, they would then make a recommendation to the Minister of Finance to put the legislation through.
Well, thank you very much.
Thank you.
Our next item on the program is a panel discussion on doing business in emerging markets. So may I ask those people in the audience who are going to participate in the panel if they would just come down and take their position at the podium here. A little curriculum vitae that have been provided to me by the individual members of the panel, and I'll start from left to right and begin by introducing you to Guillermo Sanchez. Mr. Sanchez is a lawyer who is working with Borden & Elliott on a temporary exchange assignment. He has worked with the law firm of Basham, Ringe, and Correa, one of the 3 largest law firms in Mexico since 1986. His practice is primarily in the areas of taxation and customs, including litigation. He became a member of the Mexican bar in 1990. He obtained his law degree from the National University of Mexico, and he has studied international law at both Pan American University and the University of Texas at Dallas. Beside Guillermo is Heather Innis. Innis is in-house counsel for General Motors of Canada, practicing in the area of international sales and trade law. As part of her responsibilities, she has participated in certain of General Motors' initiatives in China. From this experience, she has developed a general familiarity with legal issues related to carrying on business in China. Heather was called to the Ontario Bar in 1984 after participating in a postgraduate program in the study of international business transactions through the McGeorge School of Law. Heather also actively participates in the international law section of the CBAO as a member of its executive committee. Heather is a member of an auto industry consultation group in relation to the ongoing drafting of NAFTA, of the NAFTA uniform regulations, and a member of the International Subcommittee of the Automotive Advisory Group established by Industry Science Canada. Beside Heather is a gentleman whose name is Wayne Barrett. Prior to forming the firm of Zippen and Barrett Architects with Stan Zippen, Wayne Barrett had been employed by various architectural firms within the Toronto area. During that time, he was involved in the area of energy conservation and worked on many of the early active and passive solar demonstration projects funded by both levels of government. Mr. Barrett is partner in charge of production and is responsible for most projects from design development to client takeover. Mr. Barrett is a graduate of Ryerson Polytechnical Institute and McGill University and holds a diploma in architectural technology, a Bachelor of Architecture degree, and is a member of the Ontario Association of Architects and Royal Architectural Institute of Canada. Mr. Barrett is also a licensed pilot and is currently president of the Canadian Owners and Pilots Association, Toronto chapter.
My partner put that piece in the end, I think, just while it was away, just for a joke.
Beside Mr. Barrett is Richard Devenney, a colleague of mine. Richard practices law in Mississauga with the firm of Kaiser Mason Ball and Lewis. Richard Devenney graduated in chemical engineering in 1971 and received his law degree in 1976, both degrees from the University of Toronto. Richard Devenney was called to the Ontario Bar in 1978 and has served as a law clerk to the Chief Justice of Ontario. He's a member of the Canadian Bar Association, the International Bar Association, and the International Law Section of the American Bar Association. Since 1989, Mr. Devaney has been involved in structuring and finalizing several investments in Central and Eastern Europe. He serves as a director of the Hungarian-Canadian Chamber of Commerce. So, ladies and gentlemen, if you would join me in welcoming our distinguished panel members. You can work out between yourselves who would like to speak.
Ladies first.
Oh, I see. Is this on? A recent Fortune article identified China as the fastest growing economy in the world, with 1.1 billion consumers eager to buy everything from Coca-Cola to telephones. The International Monetary Fund has identified China as the third largest economy in the world, behind Japan and the United States. This is obviously a country that's not to be ignored, and it hasn't been. And in fact, the Chinese government has pulled out all the stops in trying to make doing business in China just a little bit easier with each passing month. However, it's still not without its difficulties. It's not like doing business in North America. I'm sure that doesn't come as a surprise to anyone. And it's important to have certain understandings of what the unique opportunities in China are, how to seize those opportunities, and most important, what role an understanding of the Chinese culture plays in the effective working within the environment. It does play a very significant role. I've been involved with certain of the activities, as we've been told by our chairman, of the initiatives that GM has in China. We've been involved in the sales of used equipment and know-how, right through to activities in our joint venture, which was set up in 1991 with the Chinese partner for the production of vehicles in the Chinese marketplace for sale to the Chinese marketplace. As part of that involvement, I've come to identify what I would consider to be 7 fundamental operating principles for doing business in China. Now, we have very limited time today, and I'm going to move very, very quickly through these. And knowing that, what I tried to do was identify for you in very much in point form, and I don't claim them to be comprehensive. I've tried to identify those points, those fundamental operating principles. In the notes that I've given you, I've tried to give you what I would consider a thought starter list. The first principle, which I think we need to talk about, although it almost goes without saying, is you don't go to China without doing your homework. This is the same principle you would have for going into any new market. It's absolutely critical that you be informed. Now, short of setting up an office in the region, which of course costs hundreds of thousands of dollars, resources that most clients just don't have to throw around for investigative purposes, you can do a lot of your research right from Canada. There are many local business associations like the Asia Pacific Foundation, the Hong Kong Trade Council, and these associations provide information for businessmen here in Canada. There are others, by the way, I'm just naming a couple. You can subscribe to the China Daily Paper. This is a publication put out by the Chinese government, and albeit somewhat biased because it is produced by the government, it does provide a very valuable source of ongoing current information. You can get on the mailing list for those law firms that are working in the area. There are local offices that are publishing relatively current issues of articles that they've written with respect to doing business in the region. These can be very effective. Stay in touch with those trade representatives at the three governmental levels, be it the local level, the municipality level, the provincial level, and the federal level, because these people will know when trade missions are going to China and when delegations are coming from China. And in fact, that leads me to another point. If a delegation is coming to Canada from China, get involved. Offer a tour of your operations. Perhaps set up a training program for those engineers or other representatives who might be traveling with the delegation. It's a great way from Canada to establish relationships and your credibility with people who may very well be the key decision makers in China. In fact, Macmillan Bloedel has effectively utilized this last item, being the setting up of training programs, to do that very same thing, to set up their credibility and relationships. Once you've amassed as much information as you feel you can amass from Canada, it's important to go to China. And that brings me to my second principle. Go to China as often as your resources will permit. It is expensive, but if done properly, it's a very, very profitable expenditure of those resources. Now, there's going to China and there's going to China. If you go to China and you haven't planned your visit well, you're going to have a very lonely, very unprofitable, very expensive trip. There are no meetings without appointments in China. However, there are several trade missions that go to China, sponsored at the three levels of government or by the several trade associations. In fact, there's one going in November that's sponsored by the municipality of Metropolitan Toronto. If you travel with these delegations to China, you're going to find that there are several doors which will be automatically open to you. You will find that there may be training seminars offered to you. There may be receptions at which you can make very valuable and necessary contacts. It may be done in conjunction with a trade show. While you're there, and actually before you go, I would suggest contacting the embassy in Beijing, the consul general in Shanghai, the Commission for Canada in Hong Kong, and the Canadian Chamber of Commerce in Hong Kong. These associations are very open to receiving calls. These embassies or representatives of the Canadian government are there to help Canadian businessmen, and they should be used. In fact, they are often very necessary to get the most up-to-date information in the region. I would also suggest while you're there that you interview local counsel. This is going to be a resource which will be invaluable to you in China in trying to work your way through the approvals processes that will be at various levels of government in China, identifying which approval will be required, when it will be required, what filings must be made is absolutely critical. By the way, in the paper, there is a typo that is rather an important typo. The Ministry of Foreign Economic Relations and Trade, the acronym for that is MOFRT. It shouldn't be with two F's, it's just one F. Once you've identified who you want to do business with, or the type of person that you want to do business with, when you get to China, or if they come to Canada, make sure you're dealing with the right people. Remember that China is a highly regulated economy, and doing business in various sectors requires licenses. If the party with whom you're talking does not have the necessary operating license, you're not going to get very far in your negotiations. They won't be able to do for you what you need them to do. As well, if you're contemplating a joint venture, ensure that there's preliminary approval that has come out of the state or local planning commission. Remember, China is still a planned economy. Once you've identified who you're going to deal with, you're sure you're talking to the right people, you've identified where you would like to work in China or where you would like to have a venture located based on a number of issues which I've identified in the paper, you're going to be sitting down at the table with these people. It's critical, and I know this is going to be said probably by the other members of the panel, to understand that nothing happens overnight. Everything is based on long-term, trusting relationships that take time to develop. It requires your patience, your flexibility, and above all, your creativity in order to overcome the hurdles that you'll be challenged with. One of the key hurdles you're going to face immediately is a communications hurdle. There aren't that many people in China that speak English. I shouldn't say that. There are many people who do, but you often will encounter people at the table who will not feel comfortable to negotiate in Chinese. And for those people who don't negotiate in Chinese, you're going to need a very highly skilled commercial translator at your side for the entire negotiations. You will also find that in most of the urban centers, in the large urban centers, you're not going to be hindered from the perspective of making your negotiations run effectively. In the large hotels, you're going to find 24-hour business centers that are as effective as the business centers you find here. In the rural centers, you better take your own PC printer, adapter, and converter with you if you plan on translating or providing a document before you leave. You must understand the issues that need to be addressed contractually. For example, the choice of law clause, certain regulations depending on the structure that you choose to undertake in China for your venture may require that you have Chinese law apply exclusively. Other types of structures may not require the application of Chinese law. Remember, of course, if you're selling goods into China, that the Vienna Convention will apply unless excluded. Both Canada and China are members to the Vienna Convention. Make sure that you're aware of and prepared for the obtaining of government approvals. And this leads me to my last point. Don't ever think that when you sign the document, you shake hands and you exchange gifts, which is the ceremony, that the negotiations are over. They're not. In fact, in many instances, the toughest negotiations are just starting. When you submit your documents to approval, depending on the type of structure that you choose and the size of your project, MOFERT or whatever agency you're dealing with may require changes to your documents. Sometimes you wonder whether the changes are required for economic reasons, compliance reasons, or perhaps just to help out the Chinese party. But in any event, you may be required at the 11th hour to make changes that you didn't expect. Now, you always have the option of walking away at that time, but that's generally not particularly realistic. As well, you'll find that the level of detail in the Chinese document is not going to be the level of detail that you normally negotiate in a North American transaction. That level of detail is going to be negotiated between the implementers on both sides. Obviously, the people who implement transactions are generally not the people who negotiate them. And with the communication challenges and the fact that certain concepts just cannot be effectively translated, you're going to find negotiations occurring on the floor, on the shop floor, or wherever. So just keep in mind that it's not over ever. There's no fat lady singing in this instance. In any event, and I think I'm probably out of time sometime over, have a look at the issues list. it does try to identify some of the things you must think about and resolve before you move into this type of venture. And observing the principles that I've enunciated and trying to get your clients to observe them will be a big help in attaining a successful venture in the long run. Thanks.
Richard, why don't you
I'd be happy to go next. Actually, in reviewing Heather's paper and considering my topic, which is really doing business in Central Europe, almost all of what Heather has said about China, you can strike out the word China and put in Central Europe. I think there are some differences, and I'll get to that in a moment. But I've done a small paper describing the lawyer's role in transactions in Central Europe as it's developed. I speak from the perspective of being a private practice lawyer who has worked with a relatively medium-sized clients, unfortunately not yet General Motors, but I remain hopeful. Anyway, the role of a lawyer in these transactions is much more than the traditional lawyering that happens in commercial transactions here in North America. However, first and foremost, you are engaged to be a lawyer and bring your legal training and knowledge of law and ability to ferret out the legal issues involved, and also to do something else that lawyers often do, and that's participate in negotiations in many different levels. But you end up doing many other things. You end up being a facilitator, perhaps almost a team coordinator of a consortium of companies that are putting together a transaction. As things have developed in Central Europe, the direct investment area is now, I think, governed largely by what we call Greenfield Investments. The problems with buying a property and a building and a structure left over from the command economy system are just so horrendous that the risks and potential future risks require a project to put together someone who's going to build a building, somebody who's going to stock it with the machinery, and also who's going to be working with doing the engineering, the architecture, etc. So often they end up being a consortium, and the lawyer, in being the interacting party with many different government agencies and between the different parties, can often act as sort of the quarterback of the project. I'm not going to go on very long because I want to leave the maximum amount of time for your questions. But some of the differences I think that exist in Central Europe, and perhaps I'll leave it as a question for Heather to respond to, is that in China you have a central authority that is directing exactly how things are going. In the countries of Central Europe, there is a great desire to have these projects go forward, but the level of democracy and media attention, where they sell their media not on the basis of advertising, but on the most interesting story to the local populace, makes the people who are making decisions about projects right on the front firing line for the first time in their lifetime. And frequently, as things have evolved from '89 to '93, you will have a decision that's you think has been taken. The bureaucrats get replaced because of the political pressure on the government to change that body, and you have to go back to square one to deal with a new set of bureaucrats who have a different problem. So not only do you have the problems of time, language, distance, culture, the fluidity of things that are going, you also have, particularly in in the Czech Republic and in Hungary, this enormous flood of substantive legislation, which is far greater than exists in Canada. And you have to keep on track of that and try and understand how it's going to affect your project. And then, as well, what they don't have is somebody who, the administrative agency that we have in the Western democracies to enforce that substantive legislation. So frequently you find yourself working in an environment where there is applicable legislation, but nobody's following it because there's no entity that oversees its regulation and enforcement. So it's a very fluid situation, and there's no hard and fast rules. It's a matter of taking those 7 principles that Heather's articulated and fitting them into all of the different roles that a lawyer might act as, which can be in the list that I wrote up in no particular order: professional advisor, facilitator, negotiator, deal maker, advance person, contact person, team coordinator, sounding board, analyst, risk assessor, and interpreter of events. And it's really an interesting exercise. It's I didn't come into this sort of notionally to become an international lawyer. I happened into it by client need, and I found it to be extremely interesting. And I invite your questions. I hope I can provide you with something useful, and I'll let my other panel members go on.
Thank you very much, Richard.
Want me to go? Okay, probably everybody's sitting out there wondering what's an architect doing talking to a group of lawyers. Well, maybe it has something to do with the economy. I'm looking for a career change based on the fact that architecture in Canada isn't doing very well. But I think I've got a unique, some unique experiences here that I could pass across, and that's one of the reasons why I accepted it when Stephen asked me if I'd like to participate today. When I looked at the agenda, I noticed it was talking to a group of general practitioners. Being an architect and in a firm of a size of a general practitioner to my clients, I think I've got the ability here to maybe pass on some of the concerns that I've got that should be expressed to your clients. And if they wanted to take it from the fact is that I guess I represent on this panel Joe Q client as far as the panel is concerned. And I've got a kind of a unique sort of perspective here because I probably represent the small businessman or person going down to Mexico that's trying to get involved in Mexico and the burgeoning market down there. And we also, I think our firm lends itself fairly uniquely because we straddle both sides of it. We're a personal service industry, just as you are. We provide service for fees. But our venture in Mexico is a unique one where we straddle personal services and we've gone over into manufacturing. Realizing that architecture is going to die as we know it in Canada, that's my personal opinion, and we'll be building in maybe 150 years ago when the architect was master builder. About 60 years ago I ventured on the taking our firm from pure architecture into design build or providing a project management basis. I've used that opportunity to expand into the Mexico market. And so what we've got is we have a development company in Mexico that is in the project management aspect. We're doing a hotel in Mexico City for a client that we're acting as project managers. And we also have a building program where we're actually building as a merchant builders for a developer. We are producing housing in Tijuana right now, and we're looking at expanding that. So that's our manufacturing side. I guess really looking at it as a typical client, then the things that you might want to pass on to your clients that they may be fairly concerned about going into the Mexico market, and the things that we found out. And again, we're a small firm, so we can't afford the specialists at $350 an hour. So we'd be probably looking at we talked with our solicitor. I've known for years, and we've trusted, and it's helped us through many difficult tasks. We sat down, we put together a list of things that we really should be looking on based on his experience. We tried to get as much information as we could, and then we went from there. The first thing that we did is we were smart. We looked at, we recognized that Mexico is a different culture, a different place, and that in order to survive, the first thing that you'd want to have is a joint venture partner. That's the first thing we looked for, and one came along, was working out very, very well. And I think that's the first thing that you might want to recommend to your clients, especially in the service industry, especially if you get into the field of construction, because it's very difficult to move into that particular market. What are the further questions that you might want to ask is that going down the list in terms of the legal system, when I first was interested in Mexico, I found out I had questions, everybody has questions with respect to the legal system down there, and everybody was concerned about social rights. I heard that the legal system in Mexico was a civil code. Well, having been trained in Quebec, I understood what a civil code was, because that's what I was trained in under the civil code system in Quebec. But it took me a while to understand the differences, and I did a little research because I just initially assumed that they were one and the same. I'm not a lawyer, I'm just a businessman and an architect, and so I don't understand these differences. I think you might want to explain how the differences of the civil code system works between Canada and Mexico. They're not the same, so everybody understands common law. As a business person, I understand common law, but when I hear civil code, I think, oh, it must be just like Quebec. There's other unique sort of things that came up in it in dealing and setting up our company down there. The structure of the company. I think that the next speaker here probably will have some good literature with respect to the different ways you can set up the companies and the legalities of it. We set up a company that, and effectively a 50-50 company, but there's a 1% share, so that we're only a 49% shareholder effectively within the company, or the country, for tax reasons and company structuring reasons. We have a 1% trustee that picks up the 50%. We found about that over a period of time, and it took me a while to understand that as a practitioner. The one thing I did find that was rather interesting that most people don't recognize in Canada here is that the Director General, the person that's responsible for our company, keeps telling us is that if we do anything wrong, they get thrown into jail. That I think is a unique experience for anybody, which is the reason why I'm not the Director General. The other one is with respect to the legal system on the street, I can give you some great anecdotes on that, including the one where we were personally hired 2 policemen to take us to the office because our license plates in our car were expired. As Canadians, I mean, the whole legal system there is one very unique for us, and I think it's kind of refreshing. Financial system. We got a real shock when we started looking at the financial system and the banking system in Mexico. We weren't aware of the fact is that our receivables from Mexico weren't valued by our banks in Canada. They don't respect them on your line of credit. Also, the interest rates. The difference between effective interest rate is that we know an effective interest rate, and what we found out was the effective interest rate in Mexico, taking into consideration devaluation of the peso, inflation, and all the rest of that. What I thought was an effective interest rate was 15% on a loan turned out to be in the order of 32%. It's something that you might want to advise your clients of. The cultural differences is really a huge one. That probably was one of the biggest factors that we're still working with today. Work style. There's a completely different work ethic and style in Mexico compared to what we're used to in Canada. Not saying whether it's better or worse. I think it's different, and I think as Canadians we have to go in and we have to try to understand and appreciate their particular way of doing business. There's a corporate style of doing business, and I'm also finding that there's a worker style on the assembly line for our factories and within the construction industry itself. So there's very, very big differences right across the board that one would want to be aware of, and certainly try to get some advice for your clients. On the agreements, we had probably this is an area where I found there was culturally there was great subtleties. In terms of agreements, things are done. We're finding things were supposedly done on handshakes. You get to know the person, and I think with respect to our partners that we have in our company, that's true. When we actually put things onto paper, I found that in the translation, what we were looking for in terms of the understanding of agreements, when they were translated to Spanish and then translated back into English, there was subtle differences that it took us a fair amount of time in order to overcome those subtle differences. I today still find extreme difficulties on the job site with my staff that I have employed on the various projects, is sitting down with them and getting them to having an understanding of the minds as to what I'm saying with respect to terms that we use in the construction industry. I think that's one that you want to get across to your clients very, very well, is that you'll have those kind of differences. The tax system, another area that I'm sure that there'll be far more technical information on. The areas within the tax structure that I found were fairly onerous was the withholding tax requirements. We operate in Mexico on the basis is that we're a service, and we provide services to our company in Mexico, staying within the 183-day requirement of being a permanent resident. And we try as much as possible to demonstrate that all of our services are done in Canada rather than in Mexico, so we're not subject to the 30% withholding tax. And I guess really on the last one is with respect to the customs. Again, I've being in the personal service, I've never really had to do anything import-exporting. I heard a couple of very good speakers today, and the one on customs was I kind of listened to very intently. We had a lot of problems importing equipment into Mexico. Our partners were Mexican. They're in the import-export business, but on a commodity not related to construction equipment. It literally took us 6 to 8 weeks to get a crane across to Mexico, and just as a little aside on that is that it took 2 weeks for us to get them to understand that a 90-ton crane wasn't a tow truck, because there was a slight differences between what we considered as a crane and what they considered as a crane on the language, and our customs official figured it was a tow truck, and we were bringing it into the free zone in Tijuana, duty unpaid. They were concerned that this crane would be used as a tow truck 7 miles south of the border. Well, I can see some 90-ton crane carrying a car. So really, my particular talk to you here is not going to be of a technical nature, but it will certainly be from a client's perspective that you would have, and what you might want to provide them with as far as information is concerned with respect to going into Mexico.
I think I have a very difficult task after hearing those comments about Mexico. I have a different point of view about Mexico. Maybe the problem in your case is that you didn't receive a good legal advice. I can give you my business card afterwards. I'm going to talk a little bit about Mexico, and what I've seen is when people talk about Mexico, they always refer about NAFTA, and I think that nowadays it is not appropriate only to talk about NAFTA when you're going to talk about Mexico. And as a matter of fact, NAFTA, we don't know if it's going to be ratified by the US Congress, so we really don't know if it's going to go into force next January of '94. Personally, I thought that by the signing of the two-side deals which intend to make NAFTA more efficient in the environmental and labor law, the US Congress was going to ratify NAFTA, but this doesn't appear to be the case. What it is important to say, is that whether or not NAFTA is ratified, Mexico has already changed, and Mexico, from my point of view, is offering a good business climate for foreign investors and also for products. The question that everybody has been asking is, what are those changes? And I could tell you that the government has undertaken a vast program of the regulation and simplification of rules. governing key sectors such as telecommunications, financial service, and also trade. The government has also undertaken a vast program of privatization, and of the more than 1,150 enterprises owned by the government in 1982, over 90% have been privatized. An example is a Mexican company of Teléfonos de México, which was sold for a price of $15 million Americans. Our tax legislation has also been changed, and in order to have a tax legislation equal to many industrialized countries, we have decreased our corporate income tax to 35%, and 2 years ago, we also reduced our value-added tax to 10%. As a result of these and many other changes, we have been able to reduce our inflation. At the middle of the 80s, our inflation was of 160%. Last year was of 11%, and the goal for this year is between 7 and 8%. This, I think, it shows how Mexico already has economic stability. We have also changed our foreign investors law. Now it establishes in which cases foreigners may own up to 100% of the capital stock of a Mexican company, or may acquire more than 49% of the capital stock or fixed asset of a Mexican company. There are still some areas that are reserved exclusively to the Mexican government, such as oil, electricity, and some financial services. But the important thing about changing our foreign investor law is that you can see that already we have increased our foreign participation. Actually, there are 9,000 Mexican companies with foreign capital participation. With respect to the financial service sector, in May of 1990, a constitutional amendment was approved, which ended the government's banking monopoly and allowed the reprivatization of the banks that were nationalized in 1982. The important thing about this amendment is that now foreign banks may own up to 30% equity of the Mexican commercial banks. An example is the Bank of Nova Scotia, who already owns 5% interest of the Grupo Financiero Inverlat. That's one of the largest Mexican commercial banks. But from my point of view, I think the biggest change has been in the trade sector. And in 1986, Mexico joined the General Agreement of Tariffs and Trades. We reduced our import duties from 100% to 20%, and we eliminated most of our import permits. As a result, last year, Mexico had imports of $46.5 billion, which shows that it's already an attractive market for foreign products. During the 80s, we also gave great support to the maquiladora industry. The maquiladora are plants operating in Mexico under special customs and are able to import under temporary basis and free of taxes raw material, machinery, equipment, and any other component used to assemble or manufacture goods that are going to be exported to the country of origin afterwards. The most important sectors of the maquiladora industry are electronic products and automotive parts. A maquiladora can also be owned 100% by a foreigner, and it can be located any place in Mexico. The Mexican government has also gave great support to the north part of Mexico, and he has created the free trade zones, and enterprises that are located in the north part of Mexico are able to import free of taxes the same machinery and equipment that the maquiladoras can do. These are part of the changes that Mexico has had, and I think Mexico has already opened the border to foreign investors and also to products, and I think that with or without NAFTA, doing business in Mexico, it's a good opportunity. And just as an example, I know that in all the countries you can find any problem, but I could tell you also, when I came to Canada, I had really difficulties going through migration, and I spent 2 hours because they thought I was going to work here in Canada, and I just came for a couple of weeks. So a problem, you can find it in Mexico, you can find it in Canada, you can find it in, hope you get a good imagine about Mexico. Thank you.
Just to rebuttal to that, I fully agree with everything he said. And really the opportunities in Mexico are fantastic. There has been incredible changes. And really what I was giving you was the anecdotes that as a an investor from Canada going to Mexico, we're used to a particular way of doing things. And I think it's important that anybody that from Canada looks at how one would go about that. And again, from a general practitioner's perspective, I think that's the kind of information that you need to put to your client. There's fantastic opportunities, but it's a different way of operating, and you have to learn how to do that. Now, once you're up to speed, I think it's fantastic opportunities, but there will be pitfalls all the way along, and those are some of the areas in which you're going to find differences. And certainly, even I know from the during this year, there has been big changes that are being made, and there will be continual to be changes, and hopefully NAFTA will go through and will eliminate some of the problems that we do have.
Well, I'd like to encourage you to ask any questions of any of the panel members. We have a very unique opportunity here, people who have experience in marketplaces that are really becoming the place to invest or do business in the future. And that applies to all of our clients, I think, that have any business of any sort of size. So if they can afford to pursue the sale into a foreign jurisdiction, these are certainly the areas that are really offering tremendous opportunities. So I'd welcome and invite you to ask any questions. We'll start with this gentleman here.
I guess this would be for Wayne and Jim. Nowadays, in Mexico, it's so easy to find interested joint venture partners. Where in the past, usually they were fairly ambivalent for having ventures with foreigners. And is this something that's temporary, just because a lot of companies are in a tight squeeze and see a foreign partner's way out, or do you see this as something more permanent?
I'm going to give you my point of view. I think the answer is that we have already changed our law, and you were not able to do a joint venture a couple of years ago the way you can do it nowadays. And I think since we have changed our law, finding or doing a joint venture in Mexico is going to keep on being a good opportunity from now on. That's my personal point of view.
I would agree. I think that from my perspective, what I've seen is that there is a thirst for technology transfer, and a lot of the companies that are looking for joint venture partners provide what I would consider is sort of the middle management skills. I personally feel is that there's an opportunity for the North Americans to take advantage of providing the skills that we have in the management sector again, looking at our perspective and with respect to the building industry. I mean, they're in the building industry in Mexico is superb, bar none, with respect to the level of skill that the tradesmen have. They're true craftsmen. We're in Canada and especially in North America, let's say, specifically Canada, from my experience, is that we tend to become nothing but assemblers. And if you can't buy it and assemble it, then how do you do it? We're in Mexico, you have extremely good skilled craftsmen. But what appears to be missing is the methodology for using the systems approach to building. And that's where I think that, again, so if you can take middle management down, show them to organize in a different way, and hence an assembly line operation, you can get fabulous achievements out of them because the quality of work is very good. So I think those are the kind of the joint ventures that are being looked for. And I personally feel that the service industry in this country has got terrific opportunities for joint venture arrangements, because that's what they're looking for is technology transfer.
Thank you. At the back?
Yeah, I have two questions. In your paper, you indicate there's a purchase tax on land, and could you explain how that applies and how it's paid? And secondly, is there an agency in Mexico that would assist investors in seeking out joint venture partners for things like real estate? Maybe Mr. Barrett can help that.
Well, the problem under the Mexican law, under the Mexican Constitution, is that foreigners, if they want to own a piece of land that is 50 kilometers within the border or 100 kilometers within the coast, they need a specific authorization, and they can just only own it by a trust. And also they have to fulfill with a certain requirements. And so I don't know if I'm answering the question you're asked. So a foreigner can own a piece of land and a real estate in Mexico, but he has to fulfill with certain requirements.
It's mentioned in the book, a tax. I'm thinking, I appreciate that there's a tax-free zone and land in coastal and resort areas, but what about a place like Mexico City if you want to develop a large parcel of land like the right thing to do right now? What tax do you have to pay on the purchase of?
There's local tax for buying real estate in the case of Mexico City, and as far as I know, there's a local tax for buying real estate in any state in Mexico. I don't know the exact regulation of this, to be honest. I don't know if you have.
But what the question would be is that, and I don't believe I don't believe you can, but within the city of Mexico, could a Canadian buy a piece of property for a commercial building, an office building, as a 100% owned Canadian?
As a Canadian, no, you will have to do it as a trust also.
That's my understanding.
And
of
the
it.
trust,
Also,
the trust will have a duration of 30 years. It could be extended for 20 years additional.
It says on page G22, a tax of 6% 92, 4% 93, and 2% 94 on the purchase. That's just the purchase function of the purchase price?
The article you have there, and I should mention that before, was written by the law firm. I'm not the specialist in that topic, so if you wish, I can write your question. I'll be glad to send you the answer.
But that's on, according to what I read there, that's on the tax on the sale of the property. So I think it's the subtleties of the interpretation here. But that's the tax is due on the sale of the property, not on the purchase of the property. It says that it may pay the tax at the rate of 30% on the profit earned on the sale.
Yeah, if you keep reading, though, there's a tax later on. It's not important, I can read it later. Now, the second question is there any agency that would assist in locating joint venture partners?
Oh, yeah. Well, you can do it.
Oh, real estate.
What is it?
It's a real estate purchase tax, yeah.
Yeah. Well, you can do it, as far as I know, people who help you in this matter is a lot of law firms that have a lot of contacts, so I don't know.
At the present rate, the way I understand it, and we've been counseled, is the best way to purchase property in Mexico is through a trust or through the joint venture, well, the company that we have set up, of which we're partners of, but is for all intents and purposes Mexican because we're not a controlling shareholder. And that's the best way we've been told to do it so far.
I think the gentleman was asking a question whether there's any agency that assists in finding joint venture partners.
As far as I know,
I'm not aware of any at the present moment, other than the fact that some of the boards of trades, and I think the Mississauga Board of Trade is actually putting together through the Mississauga EDO, Economic Development Organization, and operated by the City of Mississauga, is in the process of trying to do strategic alliances where they would find joint ventures.
I would recommend you to contact Banco de Comercio Exterior, that's Banco Mex, that they have office here in Toronto, and I'm sure they could help you find some joint venture, or maybe they can tell you to who would you have to contact in Mexico.
All right, sir.
Devaney, in representing Canadians investing in Eastern Europe, have you found it necessary to form associations with foreign, local legal counsel? And if you have, comment on the kind of arrangements that are making, how they work out?
Well, I might say actually that our firm probably has some of the best contacts in Warsaw, Bratislava, Budapest, and Prague in this country. We have participated, the lawyers at Kaiser Mason, in an exchange program operated by the Canadian Bar Association, which has brought legal interns over here and resulted in conferences of which I've been a part each year in June for lawyers in those jurisdictions. about practicing law in a free market democracy. As you can probably imagine, before 1989, under communism, there was no commercial law, there was no corporate law. And they are very quick studies, and the lawyers that have come over here have done very well and established law firms of their own, and there have been a number of American law firms, in fact, that have established offices. There are a few Canadian firms in Prague and Budapest, but not in the other jurisdictions that I know of. And I could confidently say that I have a single lawyer of choice that I would like to refer a matter to in any of those cities. And if there was a conflict of some type, I would have an alternative. And we are hosting right now a lawyer from the Slovak Republic, which is, as you know, a new country as of the beginning of this year. And she is very interested in an area that our firm is interested in, which is patents, trademarks, and copyrights. We have a couple of lawyers practicing in that area. And on the split of Czechoslovakia into the Czech and Slovak republics, the old patent, copyright, and trademark offices were all in Prague. And so now in Bratislava, they're having to establish those offices, and any companies or industries that would want to operate in that country are going to have to go through a process there. So here is a person who has come over here for 3 months to learn an area of expertise in which she is almost immediately going to become the leader in her country. It's really quite remarkable. And
Contacts and counsel that you use, have you formed any?
yes, we've got a formal association with a law firm in Warsaw. We've got informal relations with law firms in Prague and Budapest. And this lawyer that I just referenced works in the office of the Slovak Bar Association president, one of the two major law firms in Bratislava. I happen to know a lawyer who was in the first wave of people who came over in 1990, and he runs the other big office in Bratislava. And when I say big, I'm talking about 6 or 7 lawyers. This is not like what you would know here.
Thank you very much. Sir.
This is a question in connection with the Mexican land ownership situation. I've had some horror stories over the years whereby people were unable to get evidence of their ownership under a trust arrangement of a particular piece of property. It wasn't so much a title issue. It wasn't a question that they wanted to sell and couldn't give their title. They were prepared to hold. All they wanted was some evidence, a piece of paper, and something that said that they owned a piece of property. In a number of instances, it took years, and in one case, it took 15 years to get a document. And I'm just wondering if any aspects of land registration and land reform have advanced to the point where you could get evidence of ownership in a reasonable length of time.
Well, you have a land registry, and also you have a title that's expired by the notary public. So I don't know where the piece of land were. The one was the problem. But
it was coastal property, and it was under a trust, and it was a vacation property, and it was not one instance.
Our land registry has been the same for the last 10 years, and
But
we
I
haven't
think,
changed it.
again, the question may be is that with respect to the trust, like traditionally trusts were only allowed to be, in fact, I think it still is, trusts are only be allowed to be handled by banks, right? Banks, up until about a year or two ago, were government-owned and run. So I think, and I have heard similar horror stories with respect to dealing with the banks and getting into difficulty. In fact, there was one in the paper, I think just about a week ago or a week or two ago, a story of a developer from Houston who found himself in jail for 14 months because of a dispute with the bank at about 6-7 years ago, I think it was. But I think I think that's changing. But I think those kind of horror stories that we've heard, sort of like from prior to Salinas' government, I think are being rectified. But I think that would be where it came from. Is the problem is the banks are the only ones that can hold trusts, and hence they're the only ones that can hold real estate. If you want to put it in a trust, and if you were dealing literally with the government. So now that they're privatized, I'm personally finding that the banks are becoming far more open, receptive, and are very quickly moving towards an open banking system that we're more familiar with. That's my personal.
The ramifications of that kind of a delay are not limited to the individual and to his deal, but it extends to the parties that he's dealing with. As the individual starts thinking that his Mexican lawyer is a crook, his Canadian lawyer is a crook, the banks are crooks, they start imagining things which they don't know whether they're real or not, and they get extremely concerned when it takes years to get some sort of evidence that the property that they have purchased is in fact registered and validly his, and so on and so forth. And all the participants are tainted in this individual's mind or this corporation's mind with the same brush. And it's very disconcerting because you can't satisfy the individual.
I would agree, and that's where I think it's the subtleties of dealing in that foreign market, and specifically with your question on Mexico, is that they're all there. I mean, because we're used to being it so open and being able to see the title of it very quickly. Then you get into the system, and it's not a bad system. It's just that it's different, and you've got to be channeled into it, and you've got to have some faith that it's going to all come down, and we're not used to those kind of time delays. And I would agree. That's the frustration that you feel when you go down there and try to deal, and there's nothing corrupt about it. It's just takes time.
The punchline is that ultimately these properties that I'm talking about were sold and there wasn't a problem. But if it hadn't been patient people, as I say in one case, 15 years, you wonder.
Which opens up why our Canadian banks are very leery of development deals in Mexico at the present moment.
I don't think that's something that's per se foreigners are treated any worse than Mexicans. I think the system itself,
correct,
it makes no difference.
Correct.
Whether you're from Canada or you're from Mexico.
That's right.
You could have lived in Mexico for 50 generations, and you can have the
one thing that is true is
it doesn't matter.
That's correct. I agree.
Is that I mean, maybe for us it's not natural, but in one way we're used to it, and we know that it's a little bit more slow than the ways are here. So that's right. I mean, that's the way they're going to treat the same as a Mexican or a foreigner. So it's nothing.
It's the landholding system. I mean, it's so fragmented. And so, I mean, you go to a registry. God.
Any other questions? All right, well then that concludes our program. I'd like to thank all the panelists and invite you, if you have a private question or something, to come down to the front after the formal part of our proceedings have finished. So thank you all for coming today, and have a safe trip home.